Ladies and gentlemen, this is Mark Emery with the National Action Task Force. I'm here with the chief to our legal department, Michael Lenz. We have some very important information to share with you in regards to the case of the Patriot Princess in Minnesota. There are some potentially earth-shattering events that are being exposed in this case. We are exposing fraud and usurpation of authority beyond imagination. And it's very important that you understand what's going on within the court system, because this particular case is indicative and reflective of what's going on across the country. And we, the people, are not going to stand for it. Thus, this expose, and this will give you who have been following the Interchange Bistro case a very thorough and detailed update as to where we're at, where we're going, and what the impact of this case will have and already is having, one way or another. We are in the process, essentially, of exposing usurpation of authority, unlawful application of authority, unauthorized activities, and we'll get into that with you, okay? So let's jump right into it, and you can see what's going on in the courts in the United States of America, and in this particular example, in Minnesota, who some of the actors are, and we're gonna lay it all out on the table for you and everyone to see, all right? So let's jump right into it. All right, folks, we are challenging the authority of the state to rule over private business and the people of the state and much more. People have been brought up to believe falsely that all laws apply to all people at all times. And we're going to prove that simply not being the case. Okay? And this is done in the context of the governor's mandate to shut down businesses. What authority does he have to rule over the private lives of private individuals and tell them how to behave, what they can and cannot do? Okay? We all know in our gut that's not wrong. Well, we're going to show you in the law how that actually works. Okay? So, as a background, in this particular case, as I've mentioned, rights have been trespassed, authority has been exceeded. It started off with 2 criminal cases with 9 criminal counts, 2 civil cases. There have been administrative acts of intimidation, threatening to withdraw licenses, unlawful arrests, clearly unlawful arrests involved, unreasonable and excessive fines, denial of due process, violations of ethics rules, application of penalties on undefined law, and the list goes on. I could have listed more, but honestly, I ran out of space on this slide. Okay, so this is what we're uncovering in terms of the actors in Minnesota. So we start off with some of the initial legal issues which relate to the Constitution. All right, so Michael, let me turn it over to you at this point, and you can help elaborate on some of these concepts in relation to what's going on in these cases. So take it away.
Thank you, Mark. One of the first things before you engage in any kind of statutory or constitutional discussion is where do we stand as men and women in relationship to the government that we created? Well, I just said that. We stand higher than them. So the constitutions that we created were essentially for the protection of our unalienable rights. And so if we start from that perspective, then we can have a better appreciation for the limits, and we can look for those limits in the Constitution and the statutes that are written in subordination to those constitutions. So, in many cases, we want to look for jurisdiction. Actually, in all cases, you want to start to see if there are any jurisdictional challenges. And it effectively starts with the plaintiff. So in these cases, we look at the plaintiff as the state of Minnesota and presented to us in the instance or the style where state is capitalized. So we call that the big S state of Minnesota versus the little s state of Minnesota. And why is that a big deal? Well, because the Constitution, the Minnesota Constitution, says that this state shall be called the little s state of Minnesota. That's the styling that's used there. That was the styling used in the Enabling Act that allowed the territory of Minnesota under the United States government to become a state. So that there's a lot of constitutional authority for the styling. And when you look to references in the statute, there has to be a mechanism to convert one to the other. Instead of, oh, well, it's just a styling. It's just a styling of the title. Well, in legal terms, styling is important. It's very important.
So if I could interject, Michael,
sure.
So jurisdiction really comes down to what is your authority, right? Who are you and what is your authority to impose your obligations upon me?
Correct. Anytime there's a plaintiff in any case, whether it's civil or criminal, the plaintiff has to have standing in some regard. In a civil case, it would be the real, they call it the real party in interest. In other words, that party has a valid controversy or skin in the game in the civil suit that they're presenting. And in a criminal case, it has to be, effectively the authority of the de jure government. So, well, who is that de jure government? Well, they never claimed that they were the de jure government or the government. They just claimed that they were the big S state of Minnesota without any allegations as to what capacity they brought the suit. So naturally, when you're able to try to look at things from that level of detail and look at what's missing, well, if you go to the Constitution, the state shall be called little s state of Minnesota. Well, there's a conflict there. So they're called big S state of Minnesota. Now they've had a chance to revise their pleadings and all the other stuff, both in the civil and the criminal cases, but they chose not to do so. They chose to let it stand. And they actually never addressed it, neither did the court. So it still stands as a jurisdictional issue. And the reason is because there's no delegated authority to the big S state of Minnesota in the Constitution, because it's not the government that was established therein. And also there's no territory defined for the big S state of Minnesota, because it's all defined for the little s state of Minnesota, the de jure government. So those are challenges to jurisdiction, both territory and subject matter, to the court.
You mentioned the Enabling Act. That was the Enabling Act from Congress, federal.
That's correct.
Okay.
And that Enabling Act is referenced in the Constitution. And, those are the kinds of things that you have to get involved in when you're researching. And those little elements to at least put some prima facie evidence on the record for your challenge. You can't be just a wing and a prayer. It has to have some sort of basis, and in this case, it's constitutional law. If each and every official swore an oath or affirmed an oath to support the Constitution, well, if they can't call the state like it's supposed to be called, well, that's a violation.
It raises the question: who are we really dealing with? Are we dealing with usurpers?
Or are we dealing with a territory that's exclusively federal?
Which doesn't apply.
We're not making any claims, although that they could be made. But anybody who puts forth a claim has the burden of proof.
Right.
We're just challenging who they are, and that places the burden on them.
Yeah.
And they refuse to even argue the point.
Well, of course they do, because they don't have a good answer. Think of
Well,
the
there isn't an answer.
right. So think about the implications of this, folks. Just this one point alone, if exposed, would turn the entire corporate state of Minnesota on its ear. I mean, think of the implications. Let's move on. We got a lot to cover here.
Yes, lots. This is just the tip of the iceberg.
Okay, go ahead.
Setting the jurisdictional issues aside, the next constitutional issue is that the Constitution delegates no unilateral authority to the government to direct the conduct of the people in the state. So that's a starting point. If it's not delegated in the Constitution, you'd be hard pressed to have a subordinate statute to now give that authority.
Yeah, the government operates by delegated authority. Delegated by who? By the people.
Well, it's delegated in three distinct branches. And that's where the other part comes in, is that the Constitution itself actually delineates the doctrine of separation of power. And and I believe it's in Article 3 of the Minnesota Constitution. And it says that, one branch can't do the job of the other branch, nor can it delegate that function to the other branch. So it's right there as a prohibition. So right there, the governor is prohibited from making any general law or rule that affects the conduct of the people or the private businesses or organizations within the state, little s, state of Minnesota.
Okay, oaths.
Is that on the next slide?
Yeah, the oaths of office, point number 2.
Oh, yeah, sorry. So what we find in the oaths of office, and we pulled several judges, for instance, and they have pledged or affirmed support to the Constitution of the Big S state of Minnesota. Well, where is that Constitution? Because in the statutes, it refers to the little s state of Minnesota. All the oaths refer to the little s state of Minnesota. And if that's the name of the state and that's how it shall be called, then that's the Constitution to which the oath must refer. And if they're using the big S state of Minnesota, we're still uncertain as to what Constitution they're pledging support of. So the oath, if they were able to set forth where the territory of the big S state of Minnesota was, then their function delegated to the office that they serve is only valid in that territory. So hypothetically speaking, if the big S state of Minnesota was a federal state within the little s state of Minnesota, then they would have jurisdiction within that federal territory. That's a hypothesis. We're not making that claim, but we are making the claim that we don't know where that is and what Constitution that they're alleging themselves support of.
Yeah, we're simply asking, who are you? Tell us.
It's a challenge to their oath of office. It's a challenge to territorial jurisdiction. It's a challenge to their delegated authority. Where did they get it from? What is their standing to bring a claim against a woman of the state? Woman in the state.
Yeah. Show us.
But
okay.
those are the kinds of things that attorneys don't deal with. They like to just deal with statutory law and make all of their presumptions about the terms and blah, 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 and dupe the people so that they can make money.
Yeah. They operate on all these things that are assumed when in fact they need to be challenged.
Absolutely. So, and in order to challenge it, you have to have the ability to know what your standing is and know how to read the statutes in light of that standing.
Okay. So you want to start with, I think.
So number 6, so we've got that the on the executive side, the governor can't create general law. On the legislative side, or in the legislative branch, they can't delegate authority to the governor to issue any general law or rule to have the full force and effect of the law that would be, as it would be enacted by the legislature. And when you look at the what the general scope of statutory law is, it really is just for those persons who are creatures of the state, or creatures of the Constitution, or creatures of statute, or any one of the people who have engaged in a privilege that nobody else can do from the state. So once you have that perspective of the statutes, then you just have to find the definitions that support it, or show that you're not subject to it. So anyway, so the point is, at the constitutional level, the governor can't create general law over the state, and the legislature can't delegate their function to the governor to do that. The next constitutional issue is that both the federal and state constitutions prohibit the deprivation of our unalienable rights, or and those recognized under common law, without due process. So the point of dictating a medical choice to you, whether or not you're going to wear a medical device over your face, or whether or not you're going to get injected, or any other enumerated and non-enumerated kinds of personal choices that are yours and yours alone to make, cannot be taken from you without due process of law. Then go ahead, Mark.
I'm just saying, it's pretty clear cut. It's cut and dry. This is basic, fundamental constitutional law. But yeah,
and with your understanding that you have every right that you express, it's not just those that are enumerated in the Constitution. Our rights are certain and unalienable, and they're given to us from our Creator. And that's I mean, you can have anything you have. All your rights are free up until the point you infringe on somebody else's rights.
or proper.
Both of you can express those rights and then resolve it in the private, whatever controversy. That's another session. So let's the next one is both the federal and state constitutions prohibit any law or executive order that would operate as ex post facto. And any kind of, when a law is considered ex post facto is when it goes back and it changes existing relationships. That's one of the elements. And of course, the relationship between the government and the people have now been changed, right? The government's now telling the people what they can do when they have no authority to do that. Then both constitutions prohibit executive orders interfering with the obligation of contracts. So those businesses that are out there that have established their licenses with the state and paid consideration for those licenses really have a contract with the state to operate within those terms. Now, if they, effectively what these executive orders have done, as illegal as they are, we'll talk about that later, have gone in and effectively interfered with those obligations. Those businesses signed up for those business licenses with certain predefined parameters as to how they were to operate. Well, now the government has come in through these executive orders and say, well, you're not going to operate that way anymore. We're going to eliminate 50% of your capacity, and we're going to make you do things that are going to cost you money in order to operate your business that was never anticipated when they got their license. And if it had been there, they would have never gotten the license, because there's no way they could have been profitable.
And there are other contracts that a business has with suppliers, with employees, with service providers. Those are all affected.
Yeah, absolutely. It's a whole economic chain that's triggered by the interference with contract by the government.
Yeah.
And it's effectively disabled our economy nationwide. So we alluded to the fact that that the governor's executive orders are not only illegal from who they purport to operate over, and we'll talk about that a little later, but they were illegal from the standpoint that he never had authority to do it, and that authority that he claimed was in fraud. So the governor had the delegated authority to claim or declare a peacetime emergency on any one of 6 conditions. Well, the condition of a public health emergency was eliminated as a condition in 2005, and left over from the list was acts of nature. So he called the virus an act of nature in order for him to declare a public emergency. Well, that's fraud. Anytime the legislature intentionally gets rid of something, the person who executes the power cannot go back and claim that category under a different category to execute the power that they'd taken away.
Yeah, the item they removed was based on public health. I mean, that's very clear.
Public health emergency. They took it out in 2005. Well, and clearly the condition of the SARS-CoV-2 virus is a public health emergency, and everybody claimed it. The national government claimed it, and even in his first executive order, the second line is that the government declared a national health public emergency. So in his first line, he declared for peacetime emergency it was an act of nature, and his second line is the government declared a public health emergency. So that immediately tells you that he's knowingly engaged in fraud.
Not good. Okay.
So then you go back up to the governor's authority. Well, anytime the government claims to have authority over you, you have to, through the statutes that are promulgated, you have to look at, well, does the Constitution allow that power? Well, it doesn't. The preamble of the Constitution, both federal and state, are to for the purpose of preserving our unalienable rights. And when the government does things in excess of that, then it usurps it. So now when you see a statute that looks on the surface to appear to have the authority over you, then you have to start questioning the terms of art that are used in the statute themselves, which generally limits the power in order to be constitutional. Yeah. So you'll find that all of these cases of the government, they just rest on the phrase that the governor's orders have the full force and effect on law of law. Well, full force and effect of law can be anything. If I have property, I can have my own law on that property, and it has the full force and effect of law. In other words, there's consequences when you violate that law. The same with the governor. So the governor's orders have the full force and effect of law, but only upon those persons subject to the governor's unilateral authority that either exists under the Constitution, which is basically the military and those people in his charge, or those other persons subject to the legislative will under the Emergency Management Act, which are those officers which are set up to effectuate the Emergency Management Act. That's the limit of the persons who his orders have the full force and effect of law over.
And of course, all of the administrators in the executive branch.
Right. Anybody that's in the governor's charge to administrate the executive function are within the scope of the governor's authority. But you notice it doesn't have it doesn't say full force and effect of general law or full force and effect of enacted law, that has a whole different perspective. Enacted law is that which is generally applicable to those persons that the legislature or the legislative branch has exerted their will over. Again, that's generally not the people unless they're engaged in some kind of privilege or function that's granted by the state government.
Interesting.
So now we get into the definitions. Okay, so now that we have a perspective on how to enter this forest, we can start navigating a little bit. So when we look at section 12.45, which is what the 8 of the 9 criminal charges are, it applies to a person. Okay, when they define the person in there, it says define as including an individual, firm, corporation, associate. So if you look at that, it says, okay, well, somebody who doesn't have the navigating ability say, oh yeah, I'm an individual, so that would apply to me. But if the word individual is not defined in the statutes to be a man or a woman or a natural person, then we must, and with those or a private person, all of whom have their rights, which are certain and unalienable, granted or given by their creator. Now we have an individual whose the word is associated with a bunch of other words, and all of those others are legal fictions whose rights and duties are defined by the legislature. So the individual in this usage must mean an individual who's subject to the will of the legislature, and that must mean those persons that are in the emergency management function as officials to deal with the whatever the emergency condition is. And we can even find support of that with a canon of statutory construction and interpretation, that a word is known by the company it keeps, or and the company in this case would be the class set forward by the enumeration of those other entities that are there. And we just described that.
Yeah, all those other entities are creatures of the state.
Correct. Creatures of the state, or they've accepted privileges or licenses from the state in order to do something. Okay. It could be a creature of the state, a creature of the Constitution. All of those are entities whose duties and rights are defined by either the Constitution or the statutes. So at the end of the day, when we look at the penalties under 12.45, it's constitutionally repugnant to the people, and it's void for vagueness in its application to the people, the private sector businesses, or private organizations in the state. But unless you have the wherewithal to come to that conclusion from very fundamental principles of law, you will be charged and they will steamroll you.
2 points I'd like to make here. Number one is you're making very clear that people need to understand you cannot interpret legalese using the common vernacular and your general understanding of the words being used. It's all based on definitions. The definitions in law may very well and are often entirely different than what your common understanding of that word is. Okay, so that's number one. Number two, I was struck when I read section 12.45 that all it is a penalty. It does not describe a prohibited act or a compelled performance requirement or anything. It doesn't identify what's right or wrong. It just says this is the penalty and doesn't apply to anything. How do you work with that, Michael?
Well, they allude to those kinds of elements by saying anybody who willfully violates the executive order. So there's really no element in there. There's, there's no prescription of, limits. And typically when a crime is established, you'll have elements, fact elements that are necessary to meet and prove in order for the charge to stick. Like the trespass. If you get charged with trespass on somebody's private land, then there has to be a demand made by the lawful owner and a refusal to leave and not having a claim of right. So those are the three elements for trespass typically, and they come from common law, but they've been codified, and that's Minnesota law for basically private parties. So the penal statutes have been codified so that the elements are clear. The elements of prohibited conduct are clear. The elements of what the consequences of the misconduct are, and that's kind of the limits on which you'll be prosecuted, and that's how the trial goes. But in this case, it violates an executive order. Okay, well, there's a whole myriad of issues that are created by, what are the terms of the executive order? I mean, who do they apply to? What's it conditioned on? I mean, as we just have shown, there's all sorts of garbage that is underlying the premise upon which they can even bring these charges. One of the things that, a lot of times you have to find some court case that establishes the principles of law that we've kind of elucidated right now. And I found one from Manteuffel v. City of North St. Paul, and basically said that charging statute provides for misdemeanor penalties for officials who violate duties imposed by the emergency management laws. So that's a clear summation of what the statutory interpretation and the, if you're considering the realm of constitutional limitations and statutory limitations, that really sums it up as the real limit of the application for that.
Your point that it does not apply to the people.
And remember, this was found way after all of the fundamental principles were elucidated. I mean, this is just a summation of that which was set forth in the record.
Yeah, you just dug this up, so this hasn't even been presented to the court yet. So, I mean, we're building such a record. It's just a mountain that exposes criminal activity, and you'll see more of that as we go here. But this is huge. It just nullifies everything that they're trying to do. And of course, the Patriot Princess case is a high-profile case in the public eye, which is one reason why they're pushing so hard to move forward and make the Patriot Princess Lisa pay a price. But laws against them, the procedures against them, the Constitution's against them. They don't have the authority. The laws don't apply to her, and they're just digging themselves deeper into the hole. So this is actually huge, and I just can't wait to see the look on the judge's face when this gets presented. So fantastic. So let's talk about due process. How has the case been proceeding in relation to due process? It started with jurisdiction, right? You challenged jurisdiction, and what happened?
Well, it actually, the case played out in the arraignment process, where jurisdictional issues were raised by Lisa in the hearings, but also the hearings themselves were initiated without proper service of a complaint and summons according to the criminal rules of procedure. In one case, they tried to serve it to her while she was in a hearing for another case, which wasn't properly served.
And the
So
paper
yeah,
signed.
yeah, and then we then she put in objections so the due process violations are on the record from day one, and they just kept building. So one of the things that she didn't there's no acknowledged understanding by Lisa on the record as to the nature and cause of the accusations. And that's fundamental because in support of that, she made a demand for bill of particulars to get that understanding so that she could not only intelligently, knowingly, and willingly plead to the accusations, but also to prepare an adequate defense against them. And those that bill of particulars was, embedded in there was also some jurisdictional, but separate and apart from that, Lisa entered a challenge to jurisdiction and brought up some of the very same points that are here now. And then along the way, there were some new charges brought under these cases, and this prosecuting attorney requested a warrant, and the judge said, "Well, no, I'm not going to issue a warrant. Summons her to a court. We're going to have a hearing on the new charges." Well, the summons never happened. There's nothing on the record. It was never issued. It was neither issued nor served. And then Judge Butel issued a warrant for her arrest for non-appearance. He falsified the record, making a claim that there was a summons, and there isn't. There clearly isn't. And that arrest was effectuated outside of the territory of Minnesota. So there's a lot of power of the state being invoked here on fraud and denial of due process.
So these issues were raised right at the arraignment hearing, which is the very first step in the entire process. And they've ignored her challenge to jurisdiction. They need to put something on the record to establish that jurisdiction exists. They ignored her bill of particulars, which she has a right to understand the nature of the charges. They completely ignored that right. And on down the line. So right from the very beginning, there's been a huge breach of law and faith in the system. So,
well, the best thing I can say is that these judges are law unto themselves, and apparently it's true, because they're not held to account for any kind of violations of the constitutions that they affirmed an oath to support, among which is due process.
And when they just blatantly violate common due process, which has been established for hundreds of years, I mean, it doesn't take a genius to see that. And then they refuse to recuse themselves from the case because of clear bias. How else would a judge ignore these things if there wasn't bias? And it just reeks of corruption up one side, down the other. So that's how the case started. We haven't even begun yet. Okay. Go ahead.
So of the 9 charges, 8 of them were under 12.45, and one of them was for public nuisance. And that public nuisance is predicated on failure to perform a legal duty. Well, the legal duty, it has to be made known, and it has to be an enacted law, right? And so the assumption that the city prosecutor was is that a duty arose under the executive order, which again fails because the executive order doesn't apply to the people at large or their businesses.
Exactly. And so they're making a charge here that is undefined, how can you defend yourself against an undefined duty?
Yeah, this is a case where the city prosecuting attorney certainly has a malicious intent to make an example out of Lisa for defying authority that she claims to have. So there's a vindictive nature here in the city attorney, and she's trying to maximize the damage for the challenge, for Lisa's challenge, her constitutional challenge, freedom of speech, freedom of association, and the right to protest, a civil, peaceful protest against the government and their illegal mandates.
Yeah, so she's ramping up the charges, coming up with whatever she can conjure.
And that's the strategy. That's been the strategy in Minnesota. There's numbers of businesses that have been attacked by the government to force this usurpation of power.
Yeah.
And well, unfortunately, the cases get settled, and the victims wind up paying, less than what they were charged, but they think it's a win.
Yeah, they still end up paying, in addition to their losses incurred as a result of the unlawful action.
Plus their attorney fees.
Yeah, it's just a no-win situation. So that's what you get with bar attorneys in most cases, sadly. Can't win.
Well, and if they challenge the system, they're likely to lose their license, because you're challenging the status quo. Their first duty is to the court, and their second duty is to the public. The third duty is to the client.
Right. So
however they perceive that to be, and they, if you challenge the status quo, you'll find out that you're going to be on the hook.
Yeah. So they can't make any of these challenges.
No. That would be an embarrassment of the court.
Yeah. So an attorney will not do any of these things.
So we now we go and we look at the court jurisdiction of itself, and the first thing, it rules of criminal procedure basically set the prosecution in the district courts in the big ass state of Minnesota. Well, again, we don't know what territory that is. Now it could be just a I'm going to call it a usage error. Legislators see big S state of Minnesota, and that's what they use all the time. So it could be that. Okay, well, let's clear that up. They won't address it. So in a court, the judicial power extends over cases or controversies at law or in equity. That's it. So in both cases, there has to be some kind of injury or harm that needs remedy. And if there was remedy at law and it was sufficient and adequate, then you would move a case at law. If it wasn't sufficient and adequate, then you would move a case in a suit in equity to get justice. But they're predicated on some kind of duty, first of all, and some kind of breach of duty. You've caused harm or breach of duty. That settles on both of those. But now, if there's no man or woman that was harmed or injured, from under common law or contract, then that leaves the court sitting as a legislative tribunal to settle public matters of public policy. So this would be a case of, if there's no man or woman with a claim of injury or harm, then it becomes a statutory issue as a matter of public policy over persons who are subject to public policy. And that's really what's underlying this. So what we have here is a case that's denominated as criminal because of the potential jail time and the magnitude of the fine, but there's no injury. It's a victimless crime, like a number of these statutory crimes are. So it's really a policy issue. It's for persons that are subject to the legislative will.
So it comes back to who is subject to that legislative will.
Exactly.
What we pointed out in the beginning. Uh-huh.
So that covers 27, 28, and 29.
Okay.
So now we look at the city prosecutor function itself. Where's their authority? The authority of the city prosecutor is granted for prosecution of state law that occurs within their city jurisdiction. State law is the operative function. It doesn't give any authority to prosecute for executive orders. And so, from that standpoint alone, there's no state law that's with the exception of the nuisance violation. That would be a state law, but the executive order laws are clearly not enacted state law, and the nuisance order, in absence of a legal duty expressed by some enacted law, that's a nullity also.
Yeah, that's interesting.
So if you,
executive orders are based directed towards the bars and restaurants. So why wasn't the bar or the restaurant the named defendant instead of the
exactly? So not even considering the limitations on persons as according to the statute and the authority of the appellate court, the Minnesota appellate court, the executive order itself, as improper as it was, gave an edict to bars and restaurants. And in Lisa's case, she had a bar and restaurant, but instead of bringing a charge against and in the name of the bar and restaurant, she brought it in Lisa's personal capacity, which is, again, not a function of any of it. She just thinks that, oh, well, she's going to make an example of Lisa because Lisa made all the fanfare about, staying open and publishing it. And she was going to just make her a poster child of the governor's orders.
Well, so even if the order was legit, she was not a party to whom it was directed.
Correct.
Yeah. What a tangled web we weave, huh?
And typically, that's the whole reason for having a limited liability company, right?
Yeah. You set that up to limit your own liability, and here they come after you personally, regardless. So,
and there wasn't even an attempt to break the corporate veil, if you will, of the legal liability company. And that's only if they're committing fraud.
Wow. Okay, so the city attorney has no authority in that standpoint. So
now we've basically covered the criminal aspects of the actions being brought against Lisa. That now we talk about the civil actions. So the attorney general, on behalf of the big S state of Minnesota, again, we have the same constitutional challenges on the civil cases. But now we have authority challenges. So the authority claimed by the Attorney General is under 8.31, and it's limited to enacted law with respect to violations that relate to unlawful business practices in trade or commerce, like false advertising or there's a number of cases, but basically, where a business has through its normal operation causes harm to the people in the state, actual and realized harm, not prospective harm. So the Attorney General is authorized under 8.31 to investigate and prosecute, and the courts are authorized under the same statute to create injunctions and grant civil penalties and stuff. Well, but if there isn't an enacted law that describes an unlawful business practice, well, guess what? There's no jurisdiction there. There's no subject matter jurisdiction for the court, and there's no authority for the attorney general to bring it under that action. But in the complaints, he, just in case that didn't stick, he said, oh, under the common law doctrine of parens patriae, which is, it's Latin for father of the country, and it originally was the prerogative of the king to care for those persons who were unable to care for themselves, like the infants and those people that had no wherewithal. And that doctrine is expanded, judicially expanded, to basically encompass an injury to a large segment of the population that as the father of the country could get remedy or seek an injunction against the operation.
All right. But
in this case, it's, that also depends upon a realized injury. And, if a restaurant or bar is operating under the proper licensing parameters, which they were, there's no unlawful business practice. There's no injury or harm done from the conduct of that business. So
standing no jurisdiction.
Yeah, the common law doctrine of parens patriae is just wholly misplaced. It's just like, hey, I gotta have some authority, and I know it's 8.31 is really not there, but I'm going to claim it anyway. It's primary source, and see if I can get away with it. And then if that doesn't work, I'm gonna combine that with parens patriae, and generally it is a combination of those two that the action may be brought forward, not one individually.
Looks like it has more weight when you got more false claims than just one.
Yeah. Yeah.
All right. Wow. And the saga continues.
So, this court jurisdiction we just kind of explained and we touched on is that, if there's no jurisdiction under 8.31, the court is given subject matter jurisdiction. But if there's no alleged violation of an enacted state law referred to, then it can't grant jurisdictions, it can't grant civil penalties, nothing. And we just said that it lacks subject matter jurisdiction of the common law doctrine of parens patriae because there's no particularized fact alleged having proximate causation to the operation of Hanson's business, affecting a substantial segment of the population of the state. Just completely absent. It's not even alleged.
And that's the law, but do the judges care about the law?
No.
We'll get to that.
At least the Minnesota ones don't.
Here's one.
Butel is he seems to be one to create his own law. So it's the king decides. It doesn't matter what else is out there that controls his behavior. So every written law, every written procedure goes out the window when you're before Butel. It's what he thinks is best. Mm-hmm. And we don't know what his personal influences are, but they certainly aren't impartial, and they certainly aren't according to the rules of due process. So, on the record, he was clearly noticed that the judges before him had not or had acted in spite of not having proper service of summons according to criminal rules of procedure, and not having answered the challenge of jurisdiction and the challenge or the demand for bill of particulars as to the nature and cause of the accusations. Those are all fundamental rights to due process, either procedurally or substantive rights. They're all on the record. And when he got this case, because we demanded recusal for those violations, and those are on the record from the previous judges. So he takes the case and just, like nothing ever happened and everything was done right, and moves forward. And then he adds a twist of his own. So he, there was an order issued by the court wrongly to enjoin the operation of the bistro, Hanson's business, because the state had illegally revoked her licenses without authority. And while Lisa was trying to shut the business down, within that frame of 1 or 2 days after that order was issued, the city prosecutor had a fledgling come in and order a drink. Well, guess what? That violated the order of the court. So the city prosecutor requested a warrant for her arrest. The judge, I think we talked about this just before, but the judge said he wasn't going to issue the warrant. The summons should issue on the new charges. Well, guess what? The summons never issued. The hearing went and Lisa wasn't there, and Butel issued an order for warrant of arrest for failure to appear, knowing and having been noticed that the summons wasn't on the record, according to his own order.
So when you go into court, you expect to have something to stand on, to have a level playing field that you can operate within the confines of the law, manage yourself properly within established court procedures. But when none of that applies, you're walking really into a star chamber.
Well, that's exactly correct. And the whole purpose for having these civil matters or even criminal matters resolved in a court of law was to do things impartially. And when you throw the law out the window, then the playing field's uneven. And basically says, well, that judicial branch that we delegated authority to deal with the criminal and the civil issues that arise amongst this population just fails. So our only resort is to go back to see who's got the biggest guns.
Yeah. Who has the power of enforcement?
Yeah.
So as a result, Lisa didn't stand on that. She wasn't buying into the hoax, the fraud, the deception, the betrayal, the treason. And so she started coming back at him with several actions at law. So let's get into that and understand that a little bit.
So basically there was two criminal cases against her and 2 civil cases. So the 2 criminal cases, Lisa launched standalone civil claims against the actors in those cases. And in the 2 civil cases, she launched 2 counterclaims to those cases in an action at law. And then 2 other cases came up against the judges who violated due process along the way. 3 judges. 2. Yeah, 3. So 3 judges. Butel, Schwab, and Luning. And and the city of Albert Lee and the state of Minnesota. So all of these players were named in a civil action for violating her rights.
Yeah, and that was that included the Attorney General's office and
all of his attorneys.
At least half a dozen attorneys working in the AG's office. The health department, there's a long list of defendants.
Everybody who participated in the conspiracy to violate her rights under color of law and color of authority were named personally in the civil action.
In their personal capacity.
Correct.
Yeah. Okay.
So these are kind of the result. They're not kind of. These were the results. So in moving a claim according to the course of common law, if a defendant failed to serve and file a responsive pleading in the time dictated by the summons, then the plaintiff was entitled to judgment nihil dicit, which is Latin for he says nothing.
They failed to put up a defense.
Pardon me?
They failed to put up a defense, and in law, silence is consent. If you do not object when you have the opportunity to object, then you create estoppel and you can never bring it up later on.
Right. So the reason this happened is because the Department of Justice attorneys played games with the civil rules. So both from a common law capacity, which they were noticed of, in the common law rules were set forth when she filed her complaint or her declaration of claims, and according to the course of the common law, if you fail to answer in the time allotted, well, it's presumed that you agree with everything, and that the defendant or the plaintiff is entitled to judgment, and that's what happened. So they filed a motion to dismiss, but had nothing in it. It was a form only, and then they filed something after the time allotted to file a responsive pleading, which had the content, if you will, that would have supported the motion to dismiss. But given that they didn't serve it, that the substantive part in the time frame, they didn't plead. They didn't serve a responsive pleading. So this was a proper entry of judgment, nihil dicit, according to the course of the common law, and they just refused to accept that. And here's where Judge Chase came in and then took their the substantive part of the pleading that was filed after the fact and had a hearing on it and then ruled on it. So he violated everything. He violated civil rules. He violated common law procedures. I mean, this guy's just rogue. Chase is as rogue as Butel.
Anything goes.
No. Yeah, I'm going to save this. I'm going to save the attorneys from their embarrassment of over $100 million of default, way over, for playing games with the rules. I'm going to save them. I'm going to champion the day. I'm going to violate my own integrity and save them. But you can look, you can see these. This is pretty substantive. Everyone that says nihil dicit is really an unbreakable judgment. We just have to get them to realize it.
Yeah. I mean, there really is no argument against it in law or in fact. It's well established. So it's time to collect. So explain this. What's a demurrer?
Okay, so demurrer is basically an objection. It's an objection to something. Pleading is generally how it happens. So in proceedings according to the course of the common law, you can serve a responsive pleading in which you would admit or deny the facts and assert affirmative defenses, one or the other. or you could say, I'm going to demur to the complaint. And basically what you're saying there, according to the course of the common law, not according to the procedures today, but what you're saying there is that you're saying that, yeah, I admit all of this is true, but it's legally insufficient to bring the claim for whatever reason.
Okay.
So what the defendant risked at that point in time was to if the demurrer was sustained, that means the court determined that, yeah, it was legally insufficient, then the defendant won the case. The judgment was in favor of the defendant. But if the demurrer was overruled, the plaintiff was entitled to entry of judgment. So in other words, the risk that they took was, is it legally sufficient or not legally insufficient? And how confident am I to risk having a judgment against me if I'm wrong?
Okay.
But in the civil rules today, you can just throw out a motion to dismiss, and yeah, the court says, oh, yeah, no, and they move on. If it's not sustained, if it's overruled, they just move on. So there's no risk, and that's why all of them do it. And that's where the judges take advantage of not ruling on the case on merits, because they'll do it on the motion to dismiss and just get rid of it. Generally, if there's legitimacy to it, that's the mechanism to not have the legitimacy considered.
So their response was without substance. And,
well, basically, on the demurrer, the claim was for prosecutorial immunity. Well, you can't assert an affirmative defense in a demurrer. That affirmative defense has to be pleaded on fact in order to support that affirmative defense. So you cannot claim that on a demurrer, because that doesn't whether or not you have an affirmative defense is irrelevant to the legal sufficiency of the complaint. Do you follow that?
Yeah. So
yeah.
Bottom line.
So basically, the claim is that you need to dismiss this for failure to state a claim because I have an affirmative defense of this. Well, it's procedurally incorrect, and even if she would have asserted it, she didn't assert it on any fact. She claimed it on status.
Mm-hmm.
But prosecutorial immunity is whether or not the functions of their fit within the prosecutory realm. So we challenge those facts. It's like, well, you don't have authority to prosecute under 12.45 because Lisa's not one of the persons. And there were so many, and you can't prosecute a crime on an illegal order.
Mm-hmm.
And so there's so many challenges. So, a prosecutor just can't prosecute because she thinks it's right. She's got to have a basis in law and fact.
Absolutely.
And she didn't have that. And all those were elements upon which the demurrer was overruled and judgment was entered.
So in each of these cases, then these judgments stand in law.
Well, they stand, other than the judge of the case, undid everything and came up with his own thing. But
well, he tried to. He attempted to.
Well, he did, and we've got to, at least it's got to enter something to vacate that.
So those are in process then.
Yes.
Okay. So back to judicial misconduct. You filed some ethics complaints. You said enough of this. We're going to file some complaints on
Well,
violations of rules of ethics.
they would be ethics complaints, but pertinent to the case, it was to disqualify the judge from presiding over any more of it because he violated the code of judicial conduct. And in Butel's case, he issued an arrest warrant for failure to appear at a hearing in which no summons was issued commanding the appearance. So that was a clear violation of due process of law and a clear violation of rules of criminal procedure for arrest and summons issuing. And then in addition to that, there were other elements as established on the record, which would also give him cause to recuse himself of the judicial code of conduct. In other words, he was presiding over a case in which he was sued and had default judgment against him. So those were the premises, and those were the facts upon which the disqualification was pursued against him, and it started to go against with the chief judge as the first starting point. The chief judge of the district court completely avoided the issue squarely before her. So we appealed.
Open and shut, right? I mean, there was nothing to determine.
Yeah, he's not biased.
Yeah.
And nothing. The issue that was squarely before her wasn't even addressed. He just like not biased and threw in a couple of court cases relative to bias, but nothing relative to the issue that was before her. And then we took that to the appellate court, or at least it took it to the appellate court, and said, hey, the chief judge didn't even address the issue squarely before it. Well, the appellate court did the same thing. They didn't address the issue before it. That was even more highlighted.
Right in front of your face.
Yeah, and they came back and basically did the same thing. And then we went to the Supreme Court, and they did the same thing.
So they're all protecting themselves. They refuse to chastise or recognize violations of law or procedure.
Yeah, probably because they don't want to have the same thing happen against them. So they're what do they call them? Setting up favors for future.
Yeah, they're all guilty as hell. And
I saved you. Remember that time when I saved you?
Yeah. I'm
calling in my marker.
Yeah, exactly.
And essentially, I think the next one is Chase. Yeah. Chase effectively did the same thing. We talked about it earlier, and these are in the civil cases where he considered the motion to dismiss after a judgment nihil dicet entered. And he was completely noticed on the record, refused to apply the law on the record equally. And had he applied the law, he wouldn't have even heard the motion to dismiss because it was filed after the judgment nihil dicet entered.
Yeah, it's too late. It's already done.
So we went through the same process, went to the chief judge, same thing happened, went to the appellate court, same thing happened, went to the Supreme Court, same thing happened. So two judges independently went up through the ranks and nobody recognized their malfeasance in office.
Sad, very, very sad.
Well, this is the state we're in, and so it requires a lot of effort to hold these people to account. I mean, it's still going to require a lot of effort because the law isn't working in our favor, and we just have to we may have to even press it into the federal arena.
It's not that the law is not working in our favor. The law is not being applied
properly, impartially.
Yeah. The law is entirely in our favor, but no one's paying attention to it.
Exactly.
If only they would recognize the law, this would have been done a long time ago.
And our system would be saved.
Yeah. So talk about him hiding documents.
So Chase, on the civil side of things, the case is moving according to the proceedings, according to the course of the common law. And Chase doesn't recognize the common law or refuses to acknowledge the common law exists or that the proceedings are different. And, in terms of how, one of the people can establish and bring a claim to a public arena as her court to get judgment.
So by denying the common law, he's denying the Constitution and his oath.
He's actually denying a right that was established by, it's not only embedded in the Constitution, but it's also specifically enumerated in the Northwest Ordinance, which basically said that all of the inhabitants of the Northwest Ordinance are guaranteed forever the right of having judicial proceedings according to the course of the common law.
And that was the basis of the Constitution of Minnesota.
Yep, exactly.
Yeah.
So it's just hidden.
So these common law actions were entered, taken, established by the Hansen court, and he doesn't want the public to see those, and so he's sequestered those documents and taken them essentially off the record from public view.
He's hidden them from public view. They're supposedly still on the record.
Yeah,
but they're not accessible.
So the public can't go and actually see what was really happening.
Mm-hmm.
Well, the good news is we do have file stamped copies of those.
Yes.
So fascinating. Okay, so we got judges in the corner, and here's our lovely prosecuting attorney, city attorney for Albert Lee, Kelly Dawn Martinez. She's been the driving force behind all this, and basically it's a fabricated, unlawful political witch hunt. It's nothing less than that. Okay, Lisa was very public about her denial and refusal to accept the unlawful governor's mandates, and because she stood up, she gets the broad end of the bat. And so this is Kelly Dawn Martinez, and one interesting point that's much more than interesting is after she's created all this havoc, created all of this crime on the part of her cohorts in the judicial system. It's just one criminal enterprise after another. But what we found out, she doesn't have an oath of office on file, which means what, Michael? Tell us what that means.
Well, in order to be able to exercise the power delegated to any public office, there has to be an oath of office executed prior. So if there's no oath of office executed for the office, she not only cannot execute the power of office, but she does not have the immunity from the office itself that could be typically afforded to an office holder.
She's impersonating a public official is what she's doing, and acting in her personal capacity.
She hasn't perfected the power to be a public officer. Mm-hmm. Impersonating might be a little strong, but she hasn't perfected the power. So that, I guess in that sense, it is impersonating, because you walk around as calling yourself a city attorney, but you don't hold, you have no delegated authority because you can't exercise it because you failed to execute your oath of office. And that office is conditioned upon the execution of that oath.
Yeah, if you're assuming and wielding authority, which you do not have, it's nothing less than impersonating a public official in my mind.
You're not lawfully authorized to exercise. How about that one?
So then doesn't this just bring the entire house of cards down?
Well, it should.
According to law,
Yeah, according,
you know.
but there is, I have run across cases where there would be what they call a de facto officer doctrine, which, if there's some kind of defect in the office, the office holder was a de facto officer, and whatever act that they did cannot be challenged. But see, we're in the mode of challenge it right now, so it's in the current, it's in the present. So she would not be saved by the de facto officer doctrine.
So yeah, it just seems like there's no end to the ignorance and culpability of acting without authority. I mean, this whole thing started without authority with the governor, and there's been no authority granted by Constitution, by the statutes, no authority by the individuals involved. And once a public official, a public servant, steps outside the scope of their delegated authority, they are then acting in their personal capacity, and they have no sovereign immunity, no judicial immunity,
no qualified immunity, no official immunity.
Yeah, they're acting in their personal capacity. So, folks, this is going on all across the country, and people need to learn where to draw the line. They need to learn to research these things, get to the bottom of it, and find out what authority these people really have, what authority the laws has. Where do you draw the line in terms of any given law, and on down the line. So, this case has far-reaching implications. All right. Given that it can get the light of day, you can see that the issues being raised here are such that we stand to overturn the entire operation of this criminal enterprise in Minnesota.
One of the things, Mark, that we didn't mention is that there's another scheme going on, and that is the monetization of these cases.
Yeah, that's a whole nother presentation.
Yeah. Okay. Stay tuned, folks.
Yeah. What he's referring to is that we're on to some evidence that the courts create bonds on these cases, and they're making money off the bonds in the back office. And so they have other interests, let's just put it that way, in terms of the outcome of the cases. And that's a whole nother thing. So, folks, we just want you to understand that this is a watershed case. We're standing strong. We're strong on the law. We're strong on truth. We're strong on facts. We're strong on righteousness. We're strong on the righteousness of the Lord. And we ain't budging. We're going to take this thing as far as it needs to go to get the justice that is deserved in this case. And that involves not only justice for Lisa, the Patriot Princess, but justice for all of the criminal actors who are exercising false authority beyond their constitutional and delegated authority. And in so doing, we really need to bring the system back where it's the rule of law. Okay? To do this, naturally, it takes huge resources. All right. So far, just look at what we've covered, and that's not the half of it in terms of what goes into the investigations, the research, the court hearings, the case filings, all the documents. Lisa has to pay, in some cases, $500 to file one document with the higher courts. So it goes on, and we need your help. We need your help to push this momentous case forward, and others like it. We're involved in others similarly. All right, now, here is something I think you're going to like to hear about. We're not asking for donations. We believe in the free enterprise system. We believe that someone should get value for value. There should always be an exchange of value for value, which is not just standing here with our holding our hat out, asking for donations. Here's what we're doing with the National Action Task Force co-op, all right? For every $100 donation that comes in, $30, 30%, goes into a sinking fund. What's a sinking fund? A sinking fund are funds that are set aside for the purpose, with the intent to grow that, to build it, to return the funds back to the contributors. And in this system that we have set up, there's a software built behind this website. If you go to natf-team.com, our software is set up that your plan will mature when you receive 150% of what you put in. In other words, you get your money back plus 50%. No guarantees, no promises. It's a good faith, best efforts basis, but we are highly confident that with the strategy that we have, that we'll be achieving that in a short period of time. Okay, I'm not going to go out on a limb and make an estimation of time, but we feel it's very doable in a reasonable period of time. So we need supporters to push this thing forward. And we're asking you to participate in our co-op, where you saw some of the damage awards, all right? The co-op shares not only in what is built up from the sinking fund, but it also will share or benefit from any damages awards that we participate in. Naturally, if we help a case through to that point, we'll share in a part of that, okay? So there's more than one way for us to feed the co-op, and you can find out more about that in our forum. Most of you are likely already involved in our forum. If not, just jot this down. It's members.natf.world. Okay? But I would ask you, go here to natf-team.com, register a free account, participate at a level that you're comfortable with the understanding that what's going to reflect in your account, you'll be able to log in, you'll have your own account, and for every $100 contributed, I'm not going to say donated because it's not a donation, it's a contribution to which you're going to look to get a decent return on that. All right. For every plan of $100, you're going to see $30 show up in your plan in the back office. Okay. And that's the amount that's actually been applied to the sinking fund. And we'll be making announcements on developments here in the forum. Okay. So again, we're not looking for donations. Participate with our co-op and share in the rewards with us when we finally achieve victory on this and or other cases. Okay. So that's how that works. I like the idea. I hope you do too. All right. So we're here to restore the rule of law. We want you to join us. We all need to come together. And folks, whether you like to think about it or not, what happens in this case and others affects you. If you don't have law to stand on when you go into the courtroom, what do you have? You have tyranny, raping, pillaging. I mean, it's no better than being, in a star chamber with the barbarians, back in the 1100s. Okay, so we need your help. We're expecting your help. We need to come together to make this thing happen. Michael, you have done a yeoman's job on pulling out this research and presenting it in a digestible format. And really, you've got the criminals in the courtroom cornered. They've got nowhere to go. Things are established on the record. And I want to thank you for that. And mostly, I just want to acknowledge all of your hard work. Much of it has been on a voluntary basis for all of us, but we need to step things up and start making things happen. Any final comments, Michael?
Well, I'm just going to underscore what you are saying, Mark, and that is that this case isn't just about Lisa. This case is about the fundamental problems with our system today, and it's allowing the degradation of our society as a whole, because we have no remedy and no recourse, because the people don't know what their rights are. They don't know how to assert or express their rights, and if they do, the system, the status quo, would be interrupted if the remedy was given. So this is the staying power that has to be in play on every one of the people who is a patriot who engages in this. It's not just, there's no silver bullets here. You can't just come up with a form and throw it in there and they're going to roll over and wet on themselves. No, you're touching against probably, I don't know what's underlying this, but it's huge. And you can see the coordinated effort across the board with respect to the vaccines and the masks and how they're trying to usurp the power by doing these types of enforcement actions against the people. I mean, this is it. This is it. And there's any number of cases like it in multiple states.
Yeah, we're in a war for our lives. It's a war like we've never seen before. We are experiencing a full-on frontal attack to our rights, our liberties, our way of life. And you know how the state operates, folks. It's a war of attrition. They wear you down. They drag it out. They cause you to do things that you shouldn't have to do in any courtroom battlefield, knowing that you've got limited resources and you can't go the distance. They have unlimited funds. All right. So this is where we've got to come together. We need your help. Get involved with the NATF co-op, and let's win this thing in one way or the other, whether it's the collection on the judgments or whether it's the growth of the sinking fund, which is completely apart from that. You can look to not only help restore the rule of law in America, help support NATF, but also have a good chance of getting your funding back and then some. I don't want to call it an investment, but let's just say it's a good building block, perhaps, for your financial future. So give that some consideration. We've gone on long enough, folks. Thank you very much for your attention, for hanging in with us this long, and we'll look forward to talking to you after this at some point real soon. Thank you. Take care, and God bless.